Daryl Barrera Jr. was a teenager from San Antonio, Texas. He lived just blocks away from Caitlin Hernandez. Court records described his home as unstable. A psychologist said his father was harsh. His mother had done time in prison. He had tried to take his own life, more than once. He had also started hurting animals. With a hunting tool, he ended the lives of raccoons and dogs.
He struggled with an addiction to adult content. By March 2024, he was just 15, and the signs were already there. The chaos at home, the cruelty, the quiet dissent. It was only a matter of time.
On the evening of March 12, 2024, 17-year-old Caitlin Hernandez, a senior at Roosevelt High School, went out for a walk. She did not come back. She had been seen with Barrera, her neighbor. Later that night, her body was found in a drainage ditch under a nearby bridge on Del Oak Drive. Investigators noted signs that pressure had been applied to her neck until breathing stopped. They also saw head injuries from a hard impact. It looked like someone moved her into the ditch.
At first, police arrested Barrera, but they couldn't identify him. A few weeks later, they matched DNA evidence at the scene to Barrera. The court looked for reasons behind his actions. Testimony described a mix of harsh treatment at home, mental health struggles, and deep anger. He had already agreed to a no-contest plea for ending animal lives. He showed emotional instability. It was unclear if he acted without thinking or planned the act. The official record did not point to a single clear reason. The psychological view was of a young person overwhelmed by trauma. In November 2024, though still a minor, he had a hearing to decide if he would be tried as an adult. Judge William Shaw of the 436th Juvenile Court chose that path. He agreed to a no-contest plea for a reduced charge related to ending a life. He did not admit guilt, but waived a jury trial. On June 13, 2025, Judge Shaw gave him a 35-year sentence. He can ask for release after serving part of that time. During the hearing, Caitlin's family spoke. They didn't believe he had truly taken responsibility. Still, they were grateful he would spend years behind bars. Her mother said the pain never goes away. It was a moment that showed the grief hasn't faded, just learned to live in silence. The next teen's warning signs were there, but no one acted until it was too late. Ethan Robert Crumbley was born in 2006 in Atlantic Beach, Florida. He later grew up in Michigan. His parents were Jennifer, Jen, and James Crumbley. Both had minor legal issues in the past. They moved the family to Oxford, Michigan. Ethan had no record of trouble at school at first. In early 2021, he began sending alarming texts about demons and ghosts. He also harmed animals. He made improvised fire devices. He kept a baby bird's head in a jar. His parents did not seek therapy or counseling despite these warning signs. In late November 2021, James bought a 9mm Sig Sauer handgun as a gift for Ethan. On November 27th, they went to a shooting range. Ethan fired the gun several times. Jennifer shared a photo from that day showing them at the range. 2 days later, on November the 29th, a teacher saw a doodle of a handgun and a bullet. Nearby were notes saying, "The thoughts won't stop, help me," and read everywhere. School staff called his parents. They did not take steps to get help. The next day, staff found Ethan looking up ammunition online. They called Jennifer again. She texted back, "LOL, I'm not mad at you. You have to learn not to get caught." No counseling was arranged. On November 30th, 2021, at about 12:51 p.m., 15-year-old Ethan brought his loaded handgun and 50 rounds into Oxford High School. He went into a boys' bathroom and fired the gun there. Then he moved into a hallway and used the weapon against classmates. 4 students lost their lives. 7 others, including a teacher, were hurt. Investigators later saw his actions were planned. His journal showed deep anger and a need for attention. Videos made the night before revealed his plan to harm students and his hope to cause upheaval. Afterward, Ethan gave up without resistance. He was charged as an adult with 24 counts. These included 4 counts for causing loss of life, charges related to causing mass harm and loss of life, 7 counts for attempted harm, and 12 counts for having the firearm illegally. His parents, James and Jennifer, faced 4 counts each for their role in the incident. They had not secured the gun and had ignored warning signs. Those charges against parents in a school harm incident were unprecedented in the U.S. In January 2022, Ethan pleaded not responsible by reason of mental state, but withdrew that defense in October 2022. He then admitted guilt on all counts. The judge noted his detailed planning. Evidence showed he had fired through barricaded doors and aimed at vulnerable areas. This indicated deliberate intent. A key question was whether his age and mental health should reduce responsibility. In September 2023, the judge ruled that despite these factors, he could face life without the chance of release. The judge felt the danger he posed outweighed any mitigating factors. On December 8th, 2023, Ethan was sentenced to life in prison without the possibility of release, plus an extra 24 years. In court, he spoke to the judge. "I am a really bad person. I have done terrible things that no one should ever do. Any sentence that the victims ask for, I ask that you do impose it on me." In early 2024, both James and Jennifer were found responsible for their part. Separate trials showed they had ignored Ethan's growing instability and let him access the gun. In April 2024, each received 10-15 years in prison. Jennifer apologized, saying she did not understand how bad things had become. James said he was unaware of Ethan's state of mind and accepted a fair sentence. Next is a 15-year-old, one choice, and it shattered 3 families. Alex Santiago Perdomo was born in 2006. He grew up in Des Moines, Iowa, in a Hispanic neighborhood. Reports offer few details about his family. He was a teenager caught up in rising tensions around East High School in Des Moines. At 15, he attended East High like many peers. Friends and classmates said he was quiet and kept to himself. Yet he became involved in a group that later made headlines for all the wrong reasons. On March 7th, 2022, just before classes ended, several vehicles stopped near East High School. Alex was in one of those trucks. A Glock 9mm handgun was in the back seat. 8 shots rang out toward a group of students. Those students included Jose Lopez, his sister, her friend, and 2 others. Investigators matched 8 shell casings to the handgun tied to Alex. Jose Lopez was 15 and did not survive. 2 girls, Kemery Ortega and Jessica Lopez Torres, were seriously hurt. Over 35 rounds were fired across several vehicles. Police said this stemmed from group rivalries among local groups. They described it as a drive-by event meant to settle a feud between rival groups. Within hours, 6 teenagers ages 14 to 17 were taken into custody. Eventually, 10 teens faced legal action. Some cases moved to adult court. Others stayed in juvenile court. Alex faced charges for causing a loss of life and for harming others. He chose a plea agreement instead of going to trial. In November 2023, he admitted responsibility for causing the loss of life. This avoided a jury process. It led to a long placement with a chance of review later because of his age. Prosecutors said he would remain in a youth-focused facility until age 18 at the State Training School in Eldora. On November 4th, 2024, Alex Santiago Perdomo received a life sentence with the possibility of parole. He was 17 then, but the decision reflected what happened when he was 15. Another teen in the case had already received a similar placement. During the hearing, a chaplain from the training school said Alex had shown change and regret. The judge also ordered him to provide $150,000 to the Lopez family. The outcome was his admission to causing a loss of life intentionally. The sentence is long but allows for review later. Restitution is set at $150,000. The next story starts with an obsession for horror films. It ends with a real one. Tori Michael Adamczyk was born in 1990 in Pocatello, Idaho. He grew up in a suburb with his parents, Shannon and Sean Adamczyk, and his siblings. His mother worked at the local newspaper. People who knew the family later said they seemed ordinary. No one saw the dark path ahead. Tori liked making films and watching scary movies. That interest would feed into a dangerous obsession. On September 22, 2006, 16-year-old Cassie Jo Stoddart was house-sitting at her aunt and uncle's home in Tyhee, Idaho. She invited her boyfriend Matt Beckham to join her. Later, a friend, Joey Davis, dropped by. Then classmates Brian Draper and Tori Adamczyk showed up. They said they planned to go to a movie. In truth, they were checking out the empty house. That night, Adamczyk and Draper snuck back in wearing masks and dark clothes. They cut the power and carried hunting tools. Their goal was to feel powerful and get attention. Investigators later found that Adamczyk and Draper had made a list of targets. Cassie was first on the list because she would be alone. When Matt left around 11:30 p.m., Adamczyk and Draper cut power again. They crept upstairs and used sharp objects on Cassie at least 29 times. She fought hard but did not survive. The police began by checking fingerprints on the fuse box. Cassie's mother's partner was checked but cleared. Then Matt said Adamczyk and Draper had been at the house that night. When questioned, both denied it. At first, Draper broke down and admitted the truth. He said what began as a prank turned aggressive when Adamczyk started striking Cassie. They led officers to Black Rock Canyon. There, they had hidden masks, clothes, sharp tools, and a damaged videotape. Forensic teams recovered the tape. It showed a horror-style video of their planning and celebration. In one recorded line, they said, "We just took Cassie's life. This is not a joke." Another line called themselves sick in the head. Another said, "We want to be just like Scream." Those recordings were key evidence. What drove Adamczyk? He and Draper felt isolated. They liked sadistic thrills and wanted attention. They admired characters from Scream and even past school shooters. They hoped to outdo them. Draper later said, "I felt like a nobody. I'd be somebody if I did something big and bad." That honesty showed their motives. Adamczyk was arrested on September 27, 2006. He faced charges of first-degree wrongdoing and planning the act. His trial began on May 31, 2007. The tapes and canyon evidence were central. The defense said they meant to make a horror film and things spun out of control. The jury did not agree. On June 8, 2007, the jury found him guilty on both counts. Sentencing took place on August 21, 2007. He received life in prison without any chance for release, plus additional years for the planning charge. He appealed, arguing poor legal help and that the sentence violated protections for young offenders. In December 2017, Idaho's Supreme Court upheld the conviction and sentence. Attempts to reduce it failed. As of 2025, he is held at Idaho State Correctional Institution in Kuna, Idaho. Both Adamczyk and Draper remain in prison, serving life terms without release. Draper has expressed deep regret. He said, "I regret it every day of my life. You lose your entire life. I would give my life if I could change it." The next teen lived in a tent. What police found inside changed everything. Daniel Ryan Gore was born in 2005 in Oregon. By 2022, he was living on his own without parents. He stayed in a tent in Beaverton. The tent was part of a local encampment near Westside Linear Park. There is no record of a stable home or family support in court documents. Court papers describe him as a teenager who lived outdoors. He had no regular supervision. This lack of care may have allowed concerning behaviors to go unnoticed until the incident became known. On Sunday, May 8, 2022, 13-year-old Milana Lee left her Beaverton home in the late afternoon. She did not return. The next day, her mother, who worked a night shift, found out Milana was missing. She checked school and called friends. No one had seen her. By the morning of May 10th, a friend and that friend's mother followed a hunch. They went to a nearby wooded area Milana liked. They found her shoes and some clothes there. Officers began a search soon after. They found her body under a blanket, partly in a creek at Westside Linear Park. The tarp and blanket match materials seen in Gore's tent nearby. Investigators worked to identify who was involved. Surveillance footage showed Gore last seen with Milana at about 7:45 p.m. on May 8th. Cell phone data placed both of them in the woods that evening. Later, the data showed his phone returning to the encampment. Officers went to question him at a library 2 days after Milana went missing. He ran out through an emergency exit. That made officers certain they had the right person. They found him soon after, hiding on a nearby apartment balcony. Inside his tent, they found a journal containing unsettling imagery and mentions of Gore. One line read, "I feel like Dexter," referring to a TV show about a person who occasionally ends other lives. They also seized photos showing non-consensual acts and browser histories linked to disturbing material. Investigators saw these as signs he had been preparing for harmful acts. Physical evidence tied him to the incident. Straps from his tarp matched items used at the scene. His DNA and phone data placed him there. His browsing history indicated an interest in planning dangerous acts. Although he was 16 at the time, a judge moved his case to adult court. The judge decided he was old enough to understand his actions. The trial took place in November 2024 and lasted 2 weeks. Prosecutors presented cell tower data, surveillance records, DNA forensics, the journal, and social media details. They argued he led Milana into the woods with intent to harm her, saying he chose to take a vulnerable young person who trusted him and carry out his plan. On November 22, 2024, the jury found him guilty on all counts: first-degree taking of life, first-degree non-consensual act, and first-degree non-consensual harm. On December 2nd, the judge gave him a life sentence. Reports differ on when he may be considered for release under parole reform. Some say after 15 years, others say at least 30 years must pass first. He was also ordered to pay over $55,000 to Milana's family. Following his December 2nd, 2024 sentencing, Gore began his imprisonment at McLaren Youth Correctional Facility, a juvenile facility in Oregon. Now, did the system fail the next teen, or was he always destined to break? Jacob Ybanez grew up in a home that looked normal from the outside. Inside, things were far from normal. His mother was Pamela Jordan. His stepfather was Kermode Jordan. They lived in Woodland Park, Colorado. Jacob and his older brother faced years of mistreatment. It was physical, verbal, and improper contact. Court records and later testimony describe bathroom sessions. In those sessions, the boys were tied up and touched in the wrong way. Jacob also said he was forced into oral contact with his mother until he was 12. By then, he had thought about harming her to stop the mistreatment. In the early hours of December 17, 1992, Jacob carried out a planned, harmful act. He involved 18-year-old Gabriel Adams. Together, they went into the bedroom where Pamela and Kermode slept. Reports say they used a gun and a sharp weapon. They also sprayed bear deterrent spray in their faces. When they left, both parents later passed away from their injuries. Jacob was 15 at that time. His actions shocked the quiet Colorado town. The reason he gave was not a simple wish to end their lives. He said he saw no other way to escape years of mistreatment. He described his life as ongoing suffering. He said he reached a point where he thought only two choices remained: harm them or harm himself. When he pointed a gun at his mother, she asked why. He answered, "Because you were cruel." His plan did not come on a whim. He said he had thought about it for years. In 1994, Jacob faced trial for 2 counts of planned fatal acts in the first degree. His lawyer did not let him speak in court. The lawyer feared Jacob's calm manner would not sit well with a jury. The jury found him guilty. He was given a sentence of life with no chance of release. Years later, Jacob's team asked for a new trial. They argued he should have been allowed to speak in his own defense. In 2017, a judge agreed. The old verdict was set aside and a new trial was granted. Instead of going through another full trial, Jacob took a deal in November 2018. He pleaded guilty to a second-degree fatal act. In January 2019, his sentence was set at 60 years. Those years counted the 26 he had already spent in custody. After applying that credit, he could seek release under parole rules. At the resentencing hearing, Jacob spoke with rare emotion. He said that being an adult means telling the truth. He quoted harsh words he had heard as a child. "I was a disgusting, rotten boy." He said those words stayed with him. His wife, Denise, came from Northern Ireland to speak for him. She described how she knew him over years of challenges. She asked for a chance for mercy. In that hearing, a mental health expert described signs that Jacob's mother had acted in cruel ways. This supported Jacob's claim that he acted to protect himself. The prosecution still argued that the act was planned, harmful, and upsetting. They wanted the full sentence to stand. Under the plea agreement in early 2019, Jacob's term was fixed at 60 years, counted from his first arrest date. He was released from a Colorado state prison sometime in 2021. No one saw coming what happened in the next case, but he had thought about it for years. Nathan was born in late 1981. His family moved often. By his teenage years, they had lived at over 30 addresses. They did this to try to leave an unstable home behind. His mother, Julie Ybanez, was about 27 when he was born. His father was mostly absent. Nathan later said his home life had much emotional neglect, drinking problems, and frequent conflict. In a personal journal, he wrote that hidden scars from that time shaped how fragile he felt. By his mid-teens, Nathan became more withdrawn. He felt angry at times. His moods changed a lot. He went to high school in Highlands Ranch, a well-off area outside Denver. He formed a close bond with his friend Eric Jensen. Both played in a local metal band called Troublebound. On June 5, 1998, Nathan was 15. He caused severe harm to his mother Julie inside their home. The injuries were sudden and extreme. Exact details from records are not public, but it is clear what happened was very serious. Eric Jensen, who was 17, arrived during or soon after the event. He helped hide what happened afterward. He denied taking part in causing the harm. His role became central in how the case unfolded. No clear reason emerged from the records. Nathan himself said, "It just seemed to be something without a reason." His troubled childhood likely played a part. People wondered whether he had a break from reality or acted out of deep despair. The lack of a clear reason left many unsettled. Nathan was taken into custody the day after the event. He was still under 18. But authorities treated him as an adult. This was due to how serious the harm was and intense media attention. It happened just days after a major school tragedy elsewhere. That context made local attitudes harsher. His legal process began in October 1998 in Castle Rock. It lasted about 2 days. The defense did not call any witnesses. At that time, the public view in Colorado was very tough on young people accused of serious harm. Coverage stressed when suburban teens caused harm. This created a zero-tolerance setting. During closing statements, the team arguing the case described Nathan as a bad seed. Nathan later said he felt they saw him simply as a bad kid. A jury then decided he was responsible for the fatal act against his mother. 2 days after that decision, at age 16, he was ordered to remain in custody for life without a chance for release. That outcome came during a period of strict policies. In 1998, Colorado saw more young people given life terms. Later, rates of serious acts by teens went down. But in the wake of major events, strict rules were already set. Years later, rules on youth cases shifted. In 2019, Governor Jared Polis changed Nathan's terms. He became eligible to seek release after 40 years. The next teen didn't pull the trigger, but he paid the highest price. Eric Jensen grew up in Highlands Ranch, Colorado. His home was stable and upper middle class. His parents, Kurt and Pat Jensen, said he was bright, kind, and caring from a young age. He had a close family. Both parents supported him at school and in life. Eric showed empathy early on. He often checked on friends who had problems. One friend was Nathan Ybanez. Nathan later said he had difficulties at home. One night in June 1998, Eric was 17. He went into Nathan's home. Nathan was 16 then. He felt anger and fear. He believed his mother was a threat. He applied force to his mother that led to her passing. Eric watched without intervening. He later said he sat 3 feet away from somebody who was dying, and I didn't save her. I could have. After that, Eric helped Nathan and another friend clean up. They moved the body and wiped away red stains. His defense said he did not directly cause the passing. The prosecution said he knew of the plan ahead of time. They argued he helped after the act and took part in planning. The next morning, Nathan was found standing near his mother's body in a park. He was taken into custody. Eric and the other friend were arrested soon after. Prosecutors gave immunity to one friend for testimony against Eric. That friend said Eric had planned the incident and had struck Julie Ybanez with a fireplace tong. Eric's trial began in August 1999. His lawyers said he was under the influence and was confused. The jury did not accept that. They found him guilty of a first-degree charge based on planning, assisting, and hiding evidence. In August 1999, the judge gave him a life sentence with no chance of early release. He also received extra years for his role in assisting, as required by Colorado law then. In prison, Eric worked on himself. He earned a GED and an associate degree. He found faith. He got certified in CrossFit. He helped start a fitness program for other inmates dealing with addiction. He stayed aware of that night. At a 2019 hearing, he spoke with regret. I sat 3 feet away from somebody who was dying. I could have stopped it. His parents wondered why his outcome was harsher than Nathan's. Nathan, who caused the passing, later had his sentence reduced. They said they did not understand how justice worked that way. In 2012, the U.S. Supreme Court ruled that automatic life terms without chance of release for minors were not allowed under Miller v. Alabama. Colorado then changed its rules. Now, minors serving such sentences could be considered for release after 40 years. In May 2019, a judge resentenced Eric. He kept a life term, but could seek review after 40 years. With time already served, he could appear before a review board in about 10 more years. Colorado law required equal sentences for both teens because they were minors convicted of the same serious act. This rigid rule led to public debate about how young people are treated in such cases. By 2019, Eric had spent 20 years behind bars. He showed real change in leadership among fellow inmates. In December 2019, after the governor reviewed his case, his sentence was reduced and he was released early. After release, he said he felt like he was on a long-awaited break. He sat in Denver's Union Station, a place he first saw with his father as a teen. He expressed gratitude. He was thankful for the chance to start over and wanted to honor what others had done for him. The next individual was just 17. One decision changed 2 lives forever. Andrew Michael Medina was 17 when events unfolded in Colorado Springs in the late 1990s. He grew up in a normal suburban family. They were middle class. His parents took part in community activities. He was described as quiet. He went to local schools. He liked sports and video games. Friends said he was polite but often kept to himself. Over time, he began spending time with youth who got into trouble. Online records from then are hard to find. Local reports mentioned occasional shoplifting and small pranks. There was no record of serious mental health issues. But friends noticed he changed as he entered high school. On March 4th, 1999, he tried to take over a delivery vehicle at an ice cream store in Old Colorado City. He was still 17. The driver, Larry Dean Thompson, was 46. Thompson tried to drive away. In the struggle, Medina fired one shot at the driver's head. The driver lost his life at that moment. Medina ran off but was arrested nearby soon after. He faced charges under a Colorado rule. That rule applies when someone does a serious unlawful act and it leads to someone losing life. Under this rule, a person can face the most serious charge even if they did not plan for someone to lose life. At trial, the prosecution showed the store's surveillance video. It clearly showed how Medina approached and confronted the driver. The store workers spoke about what they saw. First responders described what happened at the scene. Experts confirmed the shot caused the fatal outcome. The defense spoke about his age. They said he panicked. They did not call anyone to say the driver threatened him in advance. They asked the jury to consider that he might not have planned for someone to lose life. The jury found him guilty of the most serious charge under that rule. At that time in Colorado, this charge for someone tried as an adult required a life sentence with no chance of leaving early. On June 10, 1999, the judge pronounced the sentence. Medina was sent to an adult correction facility. He was only 17. At sentencing, he spoke softly. He said he never wanted anyone to lose life. He said he only wanted to get away. Those were his only public words. They show some regret, but also the weight of what happened. As of mid-2025, he remains incarcerated at Colorado State Penitentiary. The next 14-year-old said he had no control. The court said he had no future. Evan Miller was born around 1988 or 1989. Exact records are not available. By July 2003, he was 14. His early life was hard. He lived in foster homes. He tried to end his own life multiple times, first around age 6. His stepfather treated him harshly. His mother struggled with drinking and substance problems. He did not have a stable family environment. One late summer evening in rural Moulton, Alabama, 14-year-old Evan and his 16-year-old friend Colby Smith were at Evan's trailer with their neighbor, Cole Cannon, who was 52. They were given intoxicating substances by Cannon that night. They spent the night smoking and playing drinking games. Cannon fell asleep on his couch. Later that night, Evan and Colby went back to Cannon's trailer with the plan to take money. Evan took Cannon's wallet and about $300. When Cannon woke up and reached toward Evan, Colby used a baseball bat to strike Cannon. Evan hit Cannon with his fists and then used the bat again. Before the final blow, Evan covered Cannon's head with a sheet and spoke as if he had divine power, saying words that made it clear he intended to end Cannon's life. Cannon was left badly hurt on the floor. The teens went home and then returned later. They tried to clean up the red stains. They set the trailer on fire while Cannon was inside. When firefighters arrived, they found Cannon too late. He did not survive the fire and his injuries. Psychological reports later showed that Evan had faced mistreatment, neglect, and emotional trauma throughout his childhood. His defense argued that these factors led to impulsive and reckless actions at age 14. Evan was charged in adult court for the fatal outcome during the fire. He was found responsible. On October 20, 2006, the judge gave him a life sentence with no possibility of release, following state law at that time. Colby Smith, his friend, accepted a plea deal and received a sentence that allowed for possible release in the future. Their outcomes were very different. Evan's case reached the U.S. Supreme Court in a decision known as Miller v. Alabama in 2012. The court ruled that mandatory life sentences without any chance of release for those under 18 at the time of their offense violated constitutional protections. The law had not allowed consideration of a young person's age, background, or capacity to change. The court said that sentencing for young people must include an individual review of their age and circumstances. In March 2017, Evan had a new sentencing hearing. He read a prepared statement apologizing to Cannon's family. He said he was responsible for taking away their happiness. Prosecutors said he behaved well in prison. He worked in a unit for trusted inmates and learned welding skills. In April 2021, the court again imposed life with no chance of release. The judge concluded, Evan remained beyond hope for significant change. Evan has appealed that decision and remains in prison. Up next, 3 nights, 2 lives ended. 1 child on trial. Thomas J. McCloud Jr. was born in 1993 in Michigan. By August 2008, he was a 14-year-old student at Jefferson Middle School in Pontiac. He had no known history of aggressive behavior at home or run-ins with police before what happened next. In late August 2008, McCloud joined classmates Dantes Tillman and Darren Higgins Jr. They took part in a series of street incidents in downtown Pontiac. Their focus was on men without homes. Over 3 nights, they were involved in 4 separate incidents. 2 of those incidents led to people losing their lives. The first incident took place in an alley behind a nightclub. The group came across Wilford "Frenchie" Hamilton, a 61-year-old man without a home. They caused serious harm to him. McCloud later said he struck Hamilton in the face a few times. He also joined in causing further harm after Hamilton was on the ground. Witnesses said Hamilton's face swelled badly. Afterward, they looked through his pockets and took his wallet. There was no money in it. The wallet was found nearby later. Hamilton was taken to a hospital. He suffered severe brain injuries. He passed away there. The next night, the same group found Lee Hoffman, a 65-year-old man without a home, in a small park. McCloud took part again. He said he hit Hoffman about 5 times. He also joined in kicking Hoffman after he fell down. Hoffman lost consciousness. He suffered serious brain injuries. He passed away about a month later from those injuries. During that incident, the group took about $80 from Hoffman's pockets. McCloud admitted he got a share. On the following day, they were involved in 2 more incidents with other men. In one of those, McCloud was spotted and then arrested after he ran from the scene. He was charged as an adult. The charge was for first-degree homicide in connection with theft. Prosecutors said both incidents happened while they tried to take property. In Hamilton's case, they took the wallet. In Hoffman's case, they took money. Under Michigan law, taking property while causing a fatal injury can lead to this charge. In October 2009, a jury found McCloud responsible for 2 counts of first-degree charges connected to theft. In December 2009, during sentencing, he and a co-defendant both showed emotion in court. He received a mandatory life sentence without the possibility of release. In May 2013, the Michigan Court of Appeals kept the findings but set aside the life sentence. The court cited a U.S. Supreme Court decision from 2012 about youth and mandatory life terms. The case was sent back for a new sentencing process. This new process had to consider his age at the time, his maturity, his upbringing, and whether he could change over time. His first sentence had not allowed for these factors. The initial sentence had been life in prison with no chance of release. After the appeals decision, a judge would now look at McCloud's age when the incidents happened, his background, and his potential to grow and learn. This would guide any new sentence, but as of 2025, he remains in prison. Is a broken childhood enough to explain what came next? Frederick Jackson was born on July 11, 2004, in Arkansas. Local reports say his childhood had many challenges. Between 2015 and 2018, he came to the attention of authorities at least 7 times. At age 11, he threatened to punch an assistant school principal. At 14, he took part in fights that left other students hurt. His juvenile record shows citations for disorderly conduct, third-degree battery, and receiving stolen property. His family faced serious losses. In 2019, his uncle Bradley Blackshear was shot by a Little Rock officer and did not survive. In 2020, his pregnant mother was shot and did not survive. These events weighed on Jackson, though they did not justify his later actions. On June 2, 2020, when Jackson was 15, he shot Nicholas Jones. Jones did not survive the shooting. Less than 2 weeks later, on June 15th, Jackson shot Deshaun Allen. Allen did not survive. Observers asked why he acted again so soon. Some say young people can slip further into harmful behavior when early warnings are missed. On February 20th, 2021, at age 16, he shot Dante Stanley. Stanley did not survive. That case began with a conflict that escalated. It may have involved local tensions or a personal dispute. Jackson was already a suspect in 2 earlier shootings, but still carried on. The last known incident was on April 7th, 2022, when Jackson was 17. He shot Dolan Goff. Goff did not survive. Jackson was arrested on April 12th, 2022. People have asked what drove him to act repeatedly. Some point to impulsive choices common in teenagers. Others note pressure from peers or the community. Personal trauma, losing close relatives, and trouble with authority may have affected his outlook. After his arrest in April 2022, officials charged him with 4 counts of first-degree unlawful taking of life and 4 counts of unlawful firearm possession. He faced a long legal process. In January 2024, Jackson entered guilty pleas on all counts. The local prosecutor said these were senseless acts of harm by a teenager and stressed the need for earlier help for youths at risk. By pleading guilty, Jackson avoided a full trial and jury decision. His defense likely aimed to reduce the maximum possible term. On January 10, 2024, the court imposed a 50-year term in the Arkansas correction system. He may become eligible for review of his case on May 15, 2057.